Hi, I'm Bill Price. I'm the founding chairman of the firm's trial practice group, and currently I am co-chairman with a couple of incredibly talented colleagues. My specialty is in doing trials. I am sort of the equivalent, or at least our firm's equivalent, to a barrister. I go from trial to trial presenting our client's case. And today I want to discuss one of my favorite topics, which is approaches to cross-examination. And by approaches, I don't mean the basics of cross-examination. I mean, how do you approach organizing and implementing a cross-examination after you have scoured the documents, the deposition testimony, the interrogatory answers, other discovery, to identify the favorable facts you can force the witness to testify to that will help your case. Or facts that you anticipate will impeach what the witness will say in direct examination. Now, obviously a complete discussion on cross-examination technique would take hours. And in fact, a good discussion of techniques with useful illustrations of those techniques would take days. And that would be a bit ambitious for an exercise like this. So what I want to share with you then is just some food for thought. Some things that you should think about, I believe, when you're trying to visualize what you're going to do when you stand up and you're going to cross-examine the witness. So the first thing I want to talk about is the tone of the cross-examination when you stand up to conduct the examination. And the tone you want to use is going to depend in large part on what I will call the atmosphere in the courtroom when you do the cross. Two questions should be paramount in your mind at that point. First, what does the jury think of the witness at the time you stand up to do the cross? And second, what faith does the jury have in you at the time of the cross? If the other side has done a good job on direct, it's likely that the witness will be viewed as sincere, honest, and likable. I hate likable witnesses. So when you stand up, the jury is going to have some empathy for that witness. And depending upon where you are in the trial, the jury will probably have much more empathy and trust in that witness than they have in you. After all, you're a lawyer, you're a hired gun, and really, who's less trustworthy than a lawyer? So consider the situation where the witness has been impressive and seems likable and honest, and you're a virtual unknown to the jury. You may have done voir dire or an opening, but let's say it's early in the trial and you haven't developed a rapport with the jury. They haven't seen you do something where they can trust you. So if you start out the examination with a tone of contempt, sort of playing the role of the avenging angel, you're likely to lose the jury. They won't hear you because they'll be offended on behalf of the witness. They identify more with the witness than they do you. They'll be asking themselves, why are you being so mean to this person? This witness doesn't deserve this, and the witness doesn't yet. And the problem is, you may know that this witness deserves contempt. You may know that this witness is a poor excuse for a human being, or at the very least is being fundamentally dishonest. So it's natural then to start out the examination with kind of this attitude of contempt and indignation and a stern tone. But the jury doesn't know yet that about the witness. So if you show indignation or contempt at that time, they'll align themselves with the witness and not you. And you can actually see this happen in a trial sometimes, where you can almost see the jury move to behind the witness because they're so upset that you as the attorney are treating the witness this way. Now, if you've got some great impeachment that will demonstrate at the outset that the jury has been deceived and manipulated as a result of the direct, go for it. We all pray for that type of opportunity. And it sometimes happens because of some significant overreaching in the direct examination, for example. So the atmosphere in the trial at the time may dictate, though, that you start the examination with a tone of respect so that the jury will actually listen to the questions and answers. And then you can change that tone as you unveil the true nature of the witness and their testimony. Now, I have seen so many lawyers lose a cross-examination and lose the jury not because of the substance of the examination, but because of their tone on cross-examination. You know, when I was a young prosecutor, I started many of my cross-examinations of criminal defendants using a tone of indignation and contempt. It felt good and it could be very effective. Why? Because the cross-examination took place after I had put on a compelling case for the government, after the jurors already thought with some certainty that the defendant was a criminal and couldn't be trusted. And I had developed a level of trust with the jurors because I had kept the promises that I had made in opening. You know, in those circumstances, a jury can enjoy a hostile cross. But the circumstances are different when you're in a civil case representing a defendant and cross-examining an appealing witness for the plaintiff. I learned that lesson the hard way when I started out, and many of my friends who are prosecutors and shifted to civil practice have had to learn it too. A different approach may be required, an approach that changes the atmosphere in the courtroom so that you can get to the point where you can impeach that witness effectively. Now, appropriate tone is related to other things too, such as, what are you trying to accomplish with the witness? Maybe you want to embrace the witness and use the witness's likability in your favor. Maybe you don't want to suggest that the witness is dishonest. The bottom line is, what are you trying to accomplish in this examination? And given where you are in the trial when you do the examination, how do you best accomplish it? And most of the time, it means that the tone you should start with in cross-examination is a respectful tone, a friendly tone. And then you build up to the story or the impeachment that you're going to use. The second approach I want to talk to you about is when you do the outline, structure it so that you make the impeachment and the admissions that you're going to get obvious at the time of the cross-examination. So the jury knows at the time that you're asking questions that have made a material point. If you use the cross-examination to just elicit facts, the importance of which may not be obvious, but that you're going to demonstrate to the jury in a compelling closing argument, a brilliant closing, then you're wasting your time. It's almost impossible for a juror to keep an open mind for the length of a trial. Jurors, anybody, start to reach conclusions early on, and then they hear the additional evidence and argument through the filter of the conclusions that they have already reached or that they're leaning to. Closing is usually too late. You have to make your points apparent at the earliest possible time in the trial. If you want a juror to think that a witness was dishonest, that juror better think that. That juror better experience that, have experienced that at the end of your cross-examination. So cross-examination isn't just getting good points that you're going to use later. You have to then build up these admissions and impeachments during the cross-examination so that the jury can understand their importance at the time. Now, let me give you an example. Many of my favorite examples come from the movie My Cousin Vinny. I'm sure many of you have seen that, and if you haven't seen it, you should see it. The cross-examinations that Vinny does in that movie are really good cross-examinations. I think in law schools they often use it to teach how to cross-examine an expert, for example, or to give illustrations. But if you look at how he cross-examines the fact witnesses, you'll see that he makes sure he makes his point at the time of the cross-examination. He's not waiting until the closing. For example, you may remember one of the witnesses is an individual who said he saw the defendants go into the sack of suds and then come out 5 minutes later and drive away. Now, the clerk in the cross of suds in the movie has been murdered. And Vinny is trying to say, isn't it possible that what happened is that my clients went into the sack of suds, bought some things, left, and then 2 other men came into the sack of suds in a similar car, went in and killed the clerk. And the witness says, no, that's impossible because it would have taken too long. They were only in there 5 minutes. And he knows that, because he says he started to cook his breakfast and saw the individuals go in through his window. And then when breakfast was finished, when he had finished cooking the breakfast, he saw the two individuals walk out, and that was 5 minutes. So in the cross-examination, Vinny points out that, isn't it possible that there were two separate men? And the witness says, no, there just wasn't enough time. It was 5 minutes. And then Vinny says, well, yeah, that's right, because you had started your breakfast and then you had completed it. And then he asked him, what did you make for breakfast? And this is set in the South, set in Alabama, and the witness says he made grits. And that's the key of the cross-examination. Because as Vinny points out, how could it take you 5 minutes to make grits when it takes the entire grit-eating world 20 minutes to make grits? It's a great point, but he doesn't stop there. He wants the jury to understand the point he's making. And so he keeps going. He kind of makes fun of him. And if you look at the movie, it looks like some of his questions are a little bit out of bounds, but with the right tone, you could get away with much of what he does, such as, these weren't magic grits like Jack had with Jack and the Beanstalk. I mean, these were regular grits that you were eating. And then after making the witness uncomfortable, he asks the ultimate question. He says, isn't it possible you're mistaken as to the amount of time that took place between the time you saw people going to the sack of suds and the time that you saw two people leave? He isn't afraid to ask that. And asking that, lets the jury have that experience at the time they are watching the examination. You're not leaving anything to chance. And whenever possible, you want to do that. You want to make sure that when you sit down, the jury understands the point you are making, or the points that you are making. Which leads to the next thing I want to talk to you about, and that is, don't be afraid of a witness's answer if it's not going to be believed. When I started learning trial practice, I remember one of the tenets is that you never ask a question that you don't know the answer to. You never ask a question where you might be surprised by the answer, or where you can't control the answer. And that's largely true. However, you don't need to be afraid of an answer that you can't control or that you don't know if a, quote, harmful answer is not going to be believed. And there are kind of two situations where this can be obvious. One is the example I gave in My Cousin Vinny, and in many of the examinations that you see Vinny do during that movie. And that is, if you have built up to a certain conclusion, if you have built up so that it's obvious, for example, that the witness is wrong about the 5 minutes. If you've built up so you've demonstrated that the witness doesn't have good eyesight, which is another one of the examinations in My Cousin Vinny, then if you ask the ultimate question, an answer that's inconsistent than what you would hope for is not going to hurt you. I mean, in the example, when My Cousin Vinny said, isn't it possible you're wrong about the 5 minutes? He didn't really care about what the answer was. Because if the answer had been no, the jury, or at least some of the jurors who are going to deliberate, would think, well, that's just not believable. But asking that question allowed Vinny to make the point, to underscore the point he was trying to make in the cross-examination. There's another situation where it's really useful to ask a question that you don't know the answer to, where you can't control the answer, when again, an answer against you is not going to hurt. And that's where you're kind of searching for gold. That is, the answer might be a great answer for you to use later in argument. It might underscore your case. And if you don't get the answer, it just doesn't matter. And let me give you an example of that. There was a case where, a major antitrust case, where a witness, an expert witness, was testifying on behalf of the plaintiff. This gentleman was incredibly well qualified. He was a professor at one of the most prestigious universities in the United States. He came across as a really nice guy. It's one of those witnesses who can be a nightmare to cross-examine. But he had based a big portion of his opinion on reading a deposition of a third party. this was a price-fixing case, and the third party was a major institution who had bought the product about which there was the contention that there was price-fixing. And that purchaser certainly thought there was price-fixing. At least that was what the deposition testimony indicated. But attached to the deposition were some documents that really helped the defense. And when we started the cross-examination, we were planning to go into those documents and say, well, but if you looked at this document, and if you looked at this document, no intention of asking would that change your opinion, because I wasn't sure about the witness's answer, and I had no control, and I wasn't sure the jury would disbelieve the witness. When I started asking the witness about these documents, his response was he never read them. There were many documents that were talked about and attached to this deposition, and he hadn't read a single one. And so the examination, part of it focused on the fact that you hadn't read this document, you hadn't read this document, you didn't read this document. In coming to the conclusion that this testimony in this deposition supported your case, there are all these documents that you had not read. Now, I think the jury would get the point from that, and that may have been good enough. But one of the folks I was trying the case with handed me a note, and it said, if he had given this assignment to one of his students, and the student hadn't looked at these documents, he would have given him an incomplete, if not a fail. I had never thought of that question, but when I saw it, I thought, what a great question to ask to illustrate the point I was trying to get across. And I didn't care what the answer was, because I'd already built up the testimony so that it was obvious that the job wasn't done completely. And so I was in a situation where I didn't care about the answer if it was against me. But if the answer helped me, it was going to be a nugget. It was going to be something the jury could immediately understand, and something that could then be used in closing arguments to really hammer the point that you couldn't trust this expert's testimony because he hadn't done all the work. And so I asked the question, which was, if you had given this assignment to your student to read this deposition and come to a conclusion as to whether or not that testimony, that complete deposition, supported the conclusion that there was price fixing, and if that student hadn't read all these documents, the best you'd have done was given the student an incomplete. I asked the question, and the expert said, yeah, that's probably right. When you're doing your outline, it's typical to write out the facts you can establish based upon the admissions and the documents. I want you to try another mental exercise. Ask yourself, if the witness's story is true, what else follows from that? What else must be true? And if that other thing isn't true, it means the witness's story isn't true. It's a version of the dog that didn't bark, which is a key element of a very well-known Sherlock Holmes short story. In that short story, the victim that was murdered had a dog. What's undisputed is that the dog did not bark at the time of the murder. So Sherlock Holmes concluded that, well, it clearly wasn't a stranger, because the dog would have barked if it had been a stranger. The fact that the dog didn't bark means that the person who committed the murder was known to the dog. Now, of course, using that logic, is most effective when you've established to the jury that that fact which does not exist in the case really must exist if the witness's story is true. And so if you can think of such a fact that, wow, if this is true, this fact would also be true. And if you want to use that in your cross-examination, structure your examination so that you really build up the fact that, oh, this has to be true if what you're saying is true, but it didn't happen. So let me give you an example. So we had a case where we represented two individuals who had created, directed, produced an incredibly successful television show. 2 years before that show came out and was incredibly successful, the plaintiff was at a cocktail party where he claimed that he had a conversation with the defendants, and that during that cocktail party conversation, they asked him, "What are you working on?" And that the plaintiff said he told them, "I've been working on a script. It involves the following elements," and that as the defendants listened to this, plaintiff said he understood he had an implied contract, that if they used any of those elements, that he would be compensated for it. In fact, he went beyond that and testified that as a result of that conversation, he thought defendants had agreed to enter into a partnership with him to develop that script. Now, a problem with his story is that after that conversation, that cocktail party conversation, there was never any communication between the plaintiff and defendants. And that was easy enough to establish. You could say, did you contact them? Did you email them? Have any conversations with anyone about this partnership? And that's pretty effective cross-examination. But an even better fact was that he didn't send his script to the defendants. And the reason that was a better fact is because it had been established during his deposition and through the documents that for a number of years he had been sending this script to anybody who expressed any interest in developing his project. And so to set up the dog that didn't bark cross-examination, the first thing you would do is set up the fact that you were trying to get someone to produce this script, to use your script. And in this situation, you ask someone, can I send you my script? And they said yes. That sets up in his mind the implied contract. And then he would send the script. And then he would send email after email saying, have you looked at this script? What do you think of this script? He had a pattern and practice of sending the script to anyone who even agreed to look at it. That's how he operated in trying to get his script developed and produced and put on the screen. And so after setting that up, you then turn to what he says happened in this 10 to 15 minute conversation. He said that defendants agreed to produce his story. And yet after that, he never did what he always did when he thought that he had an implied contract, that if his ideas were used, he'd be compensated. He never sent the script. Not that next week, not that next month, not that next year, not a year and a half, not 2 years later. That's an example of constructing a cross-examination, where you're not just using the facts that you know to be true, but you're building up a situation where if what he says is true, there would be another fact too, and that fact isn't there. So again, I'm Bill Price. Thank you for watching this. I hope that you found something useful that will help you in doing your cross-examinations. And if you want further information, don't hesitate to look at our website, quinnemanuel.com. Thank you.